Welcome back to another episode of So in the Know, your go-to podcast for all things shared ownership. I'm your host, Sarah Ellis, Head of After Sales at So Resi, and today's episode is especially important for anyone who's thinking of buying, owning or selling a shared ownership home. Now, I'm joined today by a specialist lawyer who is going to break it down exactly what it means to buy and own a shared ownership property. We'll be asking questions like, what is leasehold? And we'll also be tackling some pressing news like leasehold reform, service charges and building safety. So as you can see, this is an episode you are not going to want to miss. So go grab your headphones, get that cuppa. This is So in the Know. My guest here today is someone who I've known for over 20 years now. He is one of the best, if not the best, specialist lawyer that I've had the privilege of working with in my career. I'm joined today by Paul Kilshaw, partner of E.J. Winter & Son. Thank you, Paul, for joining us today.
Hi, Sarah. What an intro that is as well. Honestly, yeah, I've paid you well.
Truly deserved.
I'm Paul Kilshaw, partner of E.J. Winter. We're a firm of solicitors, been going 100 years. And I specialize.
You don't look that old.
Well, no, I've aged well. I specialise in property law, generally, and specifically shared ownership, and new homes and that type of property. So I've done it for 25 years. I've seen changes over those years, and we're still doing it today.
Many more to come.
Yep.
We've got an awful lot to get through today. Where do we start? If I was a client coming to you then, and I'm thinking of dipping my toes into shared ownership, where would you start with the advice that you'd give?
Well, it's a fairly complex area, and I think the theme that I'm going to continue to say is that it is complicated. And I think the first thing for sort of everyone looking to buy or own or live somewhere is what do they need, what do they want? And what sort of commitment do they want to get involved in relation to buying or living in a property? Because they've got options. And those options include renting. Most people live at home with their parents, buying a shared ownership property, or buying a property for on the open market for full market value. And I think that specifically when someone comes for shared ownership, they have to understand that there are massive benefits to buying shared ownership, but there are also issues and there are things that they need to know and be aware of before they take a commitment. Because buying a shared ownership property is a commitment. And ultimately, that commitment brings with it responsibilities. And I think that many people, particularly our clients, people we see, they're very keen on moving as fast as they can. They want to get into their properties, but they don't think about what happens when you come to sell, the costs of living in the property, and particularly where people have been used to renting property, they're not used to the responsibility of having to pay to maintain the property. And therefore, they have to consider things like boiler goes wrong. Traditionally, if you live in a rented property, your landlord deals with it. But if it's your property, you're dealing with it.
Yeah, exactly.
And I think that, generally you see people that come along to buy shared ownership don't necessarily understand that. And the lawyer's role is not to sit there and say, what a brilliant house or flat you're buying. It's unbelievable. The lawyer's role is to say, here are the problems. And sometimes, clients say, well, all you are is negative. And even my wife says that to me at times. And it's like, well, that's our role. We're lawyers. We're not here to tell you that everything is perfect and brilliant. We're here to tell you about the problems. And that's not to say you shouldn't buy or you shouldn't purchase or you shouldn't rent. That's simply to say, as long as you're informed as to what you're doing, then you should proceed on that basis. And I mean, shared ownership is a unique sort of brilliant way of owning properties. It's fairly rare in the world. And I think it was like 1980, I think the Housing Act came in and shared ownership as we know it today was introduced. And as the years have gone by, as houses have got more and more expensive, shared ownership has become more necessary. And ultimately, all shared ownership is you buy a share of a property. The other part of the property is owned by the housing association. And I think when it was first introduced for 10 odd years, it was virtually unheard of. House prices were fairly low. And if you think that house prices have risen almost 400% since 1974 in the UK.
That's incredible, isn't it?
You understand why it's much more difficult for someone to get on the ladder than it was previously. So I think the age of shared ownership is here now. It's taken, like everything, all changes in law take a long time. It's taken almost 40 years before people fully understand it. But now is the time for people to understand there's more opportunities for shared ownership, and there's more people actually looking to buy and move and committing to a property that they can live in and be their own property, as opposed to a rental property where the landlord can say tomorrow, I want you out.
Exactly. And that's it. It's the security of tenure. It's absolutely a necessary product. We get a lot of comments on our socials about, delays with buying their home or challenges with selling their home. Why is it so hard for some people?
Yeah, I mean, specifically shared ownership is difficult. So if you look at the housing market generally, it's archaic. English law is based upon a 1,000-year-old law that started in 1089. So housing law, property law in England is very archaic. It's not been reformed. It's complicated. So whether you buy a flat, a house on the open market, or whether you buy a shared ownership property, it takes time. It's time consuming. People find it difficult, and most of the time people don't understand that it's not like buying a product. There are uniqueness and issues with property that don't exist when you buy a car. And therefore, I think most people come to buying a property with a misunderstanding of they believe it's very easy to buy and very quick. And, we have all sorts of issues with the conveyancing system. Some people blame the lawyers. Some people blame the banks. Some people blame the housing associations. And it's very easy for people to blame everyone else, as opposed to accept actually there is a system, there's a process. There are good and bad people in those systems from time to time. And ultimately, it's not a quick process. And that's one of the things that most people will find. It's a much slower process than they envisaged. And their expectations when they come in to buying a property is that it will happen overnight. They'll be in next week. But the reality is not always the same. And with shared ownership, you have, if we take it back slightly, you have a scenario where when you buy a share of property, you obtain the lease for the property. And in English law, there's generally two types of properties you can buy. One is freehold, where you own the property absolutely. You own everything to the ground and everything to the heavens above. And the other is leasehold. And with a leasehold property, you tend to only own the floors on which the property is on. For example, if you're on a third floor flat, you'll own the third floor, and you own it for a certain number of years. So traditionally in English law, you owned it for 99 years. That has started to change. Now, leasehold properties generally are much more complicated than freehold. And so generally, if you buy a leasehold property, it's going to take longer for the transaction to go through because there's more variables. Okay. For example, with a leasehold property in a block of flats, you often have a management company that maintain the block, and they have input in relation to that. You sometimes have a separate person called a freeholder who owns the freehold of the block. And often they'll charge things like ground rent, which is a sort of archaic rent for no reason at all. And therefore, leasehold is more difficult. Now, shared ownership is like a gloss on top of that. Shared ownership is leasehold. By its very nature, you own a share. So you have a lease. So your share is via the lease. You also have another party who has a share, the housing association. They have whatever you don't have. And then often you have those other companies as well. You have management companies, freeholders, etc. So there are many people to deal with in the process of buying a shared ownership property. And those people work at different paces. And a lot of what the government is trying to do, or the new government's trying to do, is change that in relation to speeding those people up, changing the process. But it takes time. Now, there is, I mentioned that there was freehold and leaseholds. There is actually a third type of ownership of property you can have, and that's called common hold. Now, common hold is very rare. There's about 25 sites where there's common hold in the UK at the moment.
Is that all for now?
That's
Wow,
all we've got right
okay.
now. And it was introduced in 2002 by the last Labour government. It's actually a fantastic piece of legislation that does away with leaseholds. And in commonhold, it's very similar to freehold. You don't have a number of years you own it for. You own it forever. And in addition, you have a say and control on the management of your block where you live, or your development where you live as well. So it's a brilliant scheme. It was introduced in 2002. It hasn't taken off because, like everything in law, it takes a long time to get going. But from very recent King's speech, I believe the government are now looking to have a scenario where they are aiming to remove leasehold entirely, or as much as they can, and move across to commonhold. So it may be that the historic issues we've had with buying leasehold properties in particular, or properties generally, start to ease, particularly if commonhold becomes a new standard and leasehold is removed from what's there in the market. There are other issues, of course, because if you have a scenario where new properties are built and they're commonhold, what do you do with the existing ones that are leasehold? Do you create a two-tier scenario, and then do you devalue those leasehold properties? It's unknown. So it's a very complicated area. But in essence, as it stands today, you have freeholds or leaseholds, all shared ownership are leasehold properties. And commonhold is that sort of future hope that's going to make things easier, quicker, cheaper, and better. Because ultimately, if you buy a property, you shouldn't be concerned about how many years are on your lease. You should buy your property to live in forever, to hand on to your children, so you shouldn't have those worries. That system is archaic. It's based upon, English law going back so many years. We shouldn't have, leasehold is not fit for purpose. And therefore, I think commonhold is the future. But as it stands today, it's still complicated. I'm sorry, it's not easy. And instructing the right lawyers who understand it is fundamental.
Yeah. And on that note, Paul, what is it like to transact with a lawyer that isn't quite familiar with shared ownership? Because I think you've just demonstrated quite well how complicated it really is.
Yeah, I think I don't know who said it to me, but someone fairly wise once said that 99% of all lawyers give the other 1% a bad name. And I kind of like that, because it's not exactly true. But with shared ownership, if you haven't done it before, or you're not an expert in shared ownership, it's impossible to deal with a lawyer that doesn't know what they're doing. There are processes that are required in shared ownership that don't exist in normal conveyancing. Conveyancing is the process of buying a house. That's just the legal term for transferring land for a house. So those processes include dealing with the mortgage in a certain way, certain requirements in the lease. There are other rules and regulations in relation to how a seller of a shared ownership property can sell that property. There are things called nomination periods. There's all sorts of technical names in these documents that don't exist in the general market. And what tends to happen in our experience with law firms, there are some really great law firms out there that specialise, and they say they specialise in it, and they do it day in, day out. But law's become a very specialist area. And when I started 25 years ago, everyone did a little bit of everything. You did a bit of wills, you did a bit of conveyancing, you did some divorce. Occasionally, you'd pop down the Crown Court and you'd defend someone for robbing someone or something of that or shoplifting normally in Reading. But nowadays it's specialist, and nowadays you have specifically property lawyers, and inside property law you have people that specifically deal with shared ownership. You have people that specifically deal with resale transactions, new build transactions, but shared ownership is its own sort of area now, and everything has become very, very specialist. And if you don't deal with someone of that ilk, the transaction times can be huge, because shared ownership leases are quite big. They're 50, 60 pages. They're unique. If you haven't seen them before, it's going to take you a while to read them. And we have this thing in law, we say it's a left-hand pile. When you get something you don't like, you stick it in the left-hand pile. You don't look at it. You deal with all the easy stuff first. You deal with the low-hanging fruit first, and you don't deal with the technical stuff. And those transactions get delayed. And that's why quite often, if you look at turnaround times for a shared ownership, particularly a resale transaction, you're talking about 5 months. And if you compare that to a freehold house, you're talking about 5 to 6 weeks. So, that is a really hold on the market. Taking 5 to 6 months to sell a property is a bad situation to have for the market, but it's still there for a number of reasons. One of which, we hold our hands up, is bad lawyers. There are some lawyers out there that shouldn't take it on at all. But the temptation, of course, if someone rings you and says, I'm buying this house, you just say yes. And it's a unique area of law. Quite often people just take instructions when they don't know anything about what they're doing because they think they can find out as they do it. That doesn't work these days.
So how can you identify a bad lawyer? What questions should people be asking when they're picking a lawyer to act for them?
Yeah, exactly. Great. You ring them, you ask them, have you acted on shared ownership transactions before? How many? How regularly? What's the stamp duty position on shared ownership? Because stamp duty is quite complicated, and often doing some research and asking the lawyer yourself what the stamp duty position is will often identify whether someone knows what they're talking about.
That's such a great shout.
Because stamp duty is different on shared ownership depending on whether the property is new or whether the property is second-hand, and it's also different depending on whether you staircase. Staircasing is the process where you buy more shares in the property. Most people that do it day in, day out will understand stamp duty for shared ownership, and they'll say, well, is it a new property? Is it second-hand property? They'll give them the answer on the fly. People that don't understand stamp duty for shared ownership will either give you the wrong answer, or we'll say, look, we'll come back to you on that. We'll find that out because it's complicated. Well, it's not that complicated if you do it day in, day out. So I always think asking that. The other interesting one we see quite a lot is people come to us and say, I had a cheaper quote because I'm buying this new build shared ownership property and your land registry fee is more expensive than theirs. And that's a great indicator when when you've had a different quote and you see two quotes and you compare them and you see the land registry fees different. The land registry fees in relation to new build transactions are higher. Most lawyers don't realise that when they don't specialise in new build shared ownership. They're slightly higher because there's more work for the land registry. And it's quite a common thing for clients to say, I really want to go with you, but your land registry fees double the land registry fee that I've had from X or Y. So, well, I'm not sure X or Y really understand the process because the land registry fee is fixed by the government. That's the fee. I'll show you the entry. And I think that people are frightened sometimes to speak to lawyers. I maybe less so than the past, but now I still think people have got this idea that lawyers are slightly aloof. I don't think they are. They're just people. They're there to help people. I mean, ultimately, if we didn't have people buying properties, we wouldn't have a business. So, our role is to give advice, and I think it's worth having that 5-minute conversation with a lawyer. How does it work? Even ask the question, how do I sell it? Is there any restrictions on me selling it? And if someone says there's no restriction on you selling a shared ownership property, you know that they don't know what they're talking about because there are some. They're not a problem, but there are some restrictions. So ask the detail of the lawyer at the point of instruction, as opposed to waiting to instruct a lawyer who's particularly cheap, necessarily getting halfway through the transaction and realising that they're not sure what they're doing, you're not sure what you're doing, and also it's taking you time. My mother-in-law has this expression, if you pay cheap, you pay twice. I say in law, if you pay cheap, it just takes a lot longer. That's the reality.
Yeah. And the other thing is they're not always fixed. So you might get that quote initially and you find actually when you get your final invoice, they've bolted on a few bits and pieces towards the end.
Yeah.
We've got one lawyer that I've dealt with. Obviously, I'm not going to name names, but they gave a quotation and things were going a bit slow. So they said to the customer, well, I'll tell you what, we can upgrade your package to our moving faster package and you pay a premium for the solicitor to put your case towards the top of the pile. Yeah. I've never heard of that before.
Yeah. Unfortunately, it's common where the fee is very low. I think we sort of say that people some firms like to show a very low headline fee, and that headline fee wins instructions. We'd rather tell you the truth. Look, we're not the cheapest. We're not the most expensive. We'll offer you a reasonable fee, but we're not going to charge you extra. I think most solicitors now are doing that, but in the industry we're in, there are obviously cowboys in every industry. There are good solicitors, there are bad solicitors. There are great policemen, there are bad policemen. There are great housing associations, there are terrible housing associations. That's the world we live in, right? And I think, all you can do as a customer is ask questions early on, at the point of instruction, before you hand over money. What do you know? How does this work? And don't feel that you can't ask those questions. Get them out there early, And then also, as you go through the process, if it's going wrong and the solicitor's really slow or they're not responding to you, and particularly if it's in the first 14 days, cancel them. You've got 14 days to cancel a solicitor service. Yeah. Cancel them, move to someone else. They've got to refund you all the money. Move somewhere else. Don't feel like I've committed now. I can't withdraw from this transaction. No, you can't. You don't need to withdraw from the transaction. Withdraw from the lawyer. Move on. Sometimes great lawyers aren't great because they're too busy. That's the other thing. So, everyone has a different experience with different people, but don't feel you're stuck with the firm that you've instructed on day one.
Yeah, great
who's not
shout.
going right.
Great shout. And we obviously know that the Building Safety Act has come into play as well, and that is another factor to consider when you're buying and you're obviously doing conveyancing on a home.
Yeah.
What's your experience with the Building Safety Act?
Well, you're trying to make me sweat now.
Yeah.
So the Building Safety Act is one of the most complicated pieces of legislation that I have ever seen. And just to give you a sort of background on this stuff, I mean, we all know about Grenfell, and that was absolutely horrendous. And, the industry, the building industry really were telling us that things were safe when they weren't. And that is just unforgivable. And there's so much with Grenfell. But actually, if you go back, the first type of building safety that we ever saw was after the Great Fire of London. So in 1666, we had Pudding Lane went up, we had a Great Fire of London, there was no such thing as building regs. And so the first building safety we ever had come into force was just after that, to try and stop that occurring again. And we've had over the best part of 400 years, various pieces of legislation that keep coming and trying to do things. Now, what the problem with legislation is, things change and move on very quickly. So the Building Safety Act, the idea behind the Act is actually brilliant. It's to ensure that all buildings, particularly high-rise buildings above 11 metres, are safe, whether it be cladding, fire systems. It's not just cladding. Everyone thinks it's cladding.
Yeah,
it's not just cladding. Building safety relates to far more than cladding, and there are some people that kind of confuse the difference between, there's no cladding, so it must be safe. Yes, it's great there's no cladding, or that the cladding is safe, but it's not necessarily the case that the building is now safe because there's no cladding. So the Building Safety Act is one of these great big acts that does a number of things, creates a building safety regulator, imposes obligations on relevant people, landlords, the original builders, to basically remedy the defects in their buildings from a safety perspective. Now, one thing, as sort of looking at the minutiae of the detail, which is probably not relevant for now, but the general thing is, when you buy a leasehold property or a property above 11 metres, you want to be making sure that a leaseholder's certificate has been served on the landlord, and that equally a landlord certificate has been served explaining the situation in relation to building safety. In that scenario, as long as the right process is followed, and you'll need a lawyer that understands it to follow those processes, you have an element of protection should it later be discovered that works for the building are necessary in relation to the building safety. Not complete protection. It's a complicated act, so I can't sit here and say you're completely covered. But one thing that really occurred to me is that in relation to building safety, some people, some builders, some developers, some housing associations have stood up and they've said, you know what? It should never be the responsibility of the people who have bought these properties living there to pay to fix issues that relate to building safety. And I'm not really here to sort of praise anyone, but I think you should take a sort of standing ovation for the point where Metropolitan Thames Valley stood up and said, you know what? If you've got a building safety issue, we fix it. Yeah. And I think that's a unique selling point, because in relation to the industry, that's not happened from everyone. Some developers have stood up and said that, some other housing associations said that, but generally people haven't said that. So they've left it up to the individual tenants, leaseholders, people that own the flats to try and fix this and figure it out themselves. And I think that Metropolitan Thames Valley standing up saying we're going to sort any issues relating to building safety we will fix is a brilliant thing to say, and I think it's a massive selling point. It gives security to people buying, knowing that they can buy their property and they're not going to have an issue with safety. It's the last thing you want. You shouldn't be buying with an issue with safety.
Yeah, and it is something that we don't actively promote. It's something we do because we believe that it's right, and we've created our letter of assurance that I'm sure you've seen, time and time again. And that letter of assurance basically covers the leaseholder, that they know they're moving into that property and they're not going to be liable for any remedial works that fall off the back of the survey inspections. And it's actually recognised by banks now. So a lot of mortgage lenders now know that we offer a letter of assurance, and that is part of their checklist now, which is great. And I do know that some providers aren't doing that, and it was actually speaking to some of the lawyers that we work with, where leaseholders, some leaseholders are actually given quite a significant bill to contribute towards remedial works.
I mean, listen, you should have a banner outside your offices advertising it. It's massive, right? And as a lawyer, we actually choose, in our business, we choose who we work with on the main. We've been fairly successful. We're fortunate that we've worked hard, but we've got some great and loyal clients and customers. And we specifically choose to work with those businesses that have made that pledge. Those businesses that made that pledge give us security, give our clients security, and they facilitate the process of selling these properties. Where a housing association or an original developer has not made that pledge and someone is buying a property on the 18th floor of a block, it's an issue for lawyers. And those transactions take significantly longer. And there are many lawyers, in fact, we often get phone calls every day from lawyers saying we refuse to deal with those transactions because lawyers don't like risk. And it's really risky for a lawyer to entertain someone buying a property where in 3 or 4 years' time they come back and say, you know what, I've just been lumbered with a bill for 10 grand because there's a massive issue with the fire system in the building that we found out about. And that can happen. And lawyers don't want that risk, and so ultimately, we as a business choose who we work with, and we've chosen yourself and several others to work with where you've made that commitment. And that commitment is not cheap. I imagine that runs into the tens of millions of pounds a year for you to spend on fixing that stuff. And it's not just cladding, it's everything else that goes with it. You've not just committed to cladding, you've committed to everything in relation to the Building Safety Act. And therefore, that gives people security that just doesn't exist in the general marketplace today.
And there are some lawyers, again, as you've just explained, Building Safety Act is a hugely complicated matter. There are some lawyers who, because of the complexities, they won't actually transact on any matters that have a Building Safety Act associated. Yeah, I mean,
I've just redone my indemnity insurance. Every lawyer has an indemnity insurance policy, and it asks you, do you do conveyancing? Well, of course I do, done it for a few years. And it says, do you deal with transactions where the Building Safety Act applies? And they want to know how many you've dealt with, when you dealt with them over the last 3 years or 2 years in relation to that, who the developers were, who the houses, and they care. Now, why do indemnity insurers care? They care because they know that claims will come in relation to this act. And therefore, they don't want to insure people that they're going to be paying claims for. And therefore, lawyers, they're risk adverse. They're not going to act in relation to transactions they either don't understand or B, that may cost them from an insurance perspective. So it's really difficult. I think, it was a sort of rushed piece of legislation, the Building Safety Act 2002. It's really complicated. It's not all in force. It's coming into force. We're starting to understand it. I can't profess to be the leading person on it. No one really can. No one fully understands the implications of every bit. But where you have original developers, housing associations, or the relevant person saying they'll accept responsibility, that removes all risk for clients. And so really clients that know that don't have to worry about the impact of the act. Everyone else, they need to worry about it. Yeah. And they need to instruct someone that has half a clue what they're doing with it as well. And it's complicated. So, that is the reality of the situation as it stands today. Okay, I think that was really well explained. And dare I say it, shall we move over to the Leasehold Reform Act and have a look at some of the changes? Some of them are really quite positive, I'd say. And also some of the changes that have come in quite recently on assessing buyers' affordability. So perhaps we could start with that one. It only seems to be outside of London for now. We're waiting to hear that residents in London will be able to follow the same suit. But instead of having a calculator, an HCA calculator, to see if you can qualify to buy a shared ownership home, Capital Funding, Homes England, have now changed to budget planners, which I think is such a fantastic move. So rather than doing a spreadsheet and it's got a computer says no scenario, financial advisors will sit down with a buyer and they will go through all of their finances and they will be able to assess whether that property is affordable now and in the future. And they actually look at calculating projected costs for the next 5 years to make sure that that property is affordable and sustainable for a few years to come. So that's one of the changes that I'm really, really pleased about. But let's also look at the leasehold reform, and I'm sure that we're going to hear more and more changes coming into effect. What's your take on it? Yeah, I mean, I think on the affordability, just point quickly, that's really a positive step forward. And actually, strangely, with shared ownership, people often look at the year one cost or the initial cost, and they don't sort of look ahead in relation to what things cost and how that works. And often people just compare the initial costs with renting. So they say, well, look, to rent, there's no friction cost. It doesn't cost me to instruct a lawyer. It doesn't cost me to to pay stamp duty if there's stamp duty due. But with most shared ownership properties, you don't pay stamp duty. But if you look over 5 years, there's often a bigger difference. If you rent for 5 years, yes, you don't have that initial outlay in cost on legal fees or perhaps stamp duty, but you've got rent that rises over that time. So I think, that's a great way of doing it now, looking at that. On leaseholder reform. Now, listen, I could talk for 5 hours on this, and I have this general feeling about leaseholds that they are just not fit for purpose. And I don't know whether I'm going to speak out of turn from the industry, but my personal view on leaseholds is that we shouldn't really have leaseholds. And I think you go to buy a property, you're a young person or even a slightly older person these days buying the first property. I don't know what the average age of a person buying a property is. Why are you concerned about how many years left you've got on the lease? Why are you concerned about paying ground rent to a person that has nothing to do with the property just because historically they own the freehold of the building? Why are you concerned about these? Why are you concerned about management companies charging you £1,000 to give you information they should give you for free or for very cheap? That shouldn't be a consideration. And the way leasehold has gone, it's been very favourable to those people that make a profit out of leaseholders. Why should anyone make a profit out of where someone lives? There's a fundamental issue for me about, do you have a right to have a property? Should everyone have a home and a roof over their heads? Or should someone be able to commercialise that and make a profit in relation to someone having that? So leaseholds generally, just to sort of recap, when you buy a leasehold property, you buy it for a certain number of years. In law, we call that term of years absolute. It basically means you own it for a certain number of years. Now, generally, you have to extend your lease once you get down to about 80, 85, 90 years because mortgage lenders consider it to be an issue, because historically there was other issues once you get below 80 years. And what's happened with the Leasehold and Freehold Reform Act is that they've slightly amended that. It was a sort of rush piece of legislation. It was, I think it was one day before Parliament closed, or on the day Parliament was closing, it came in and they signed it off. And what we were hoping for in relation to that act was we were hoping for either a cap on ground rents, so that ground rents were limited to a certain amount, ideally £250 for technical reasons, or an abolishment of ground rents. Because what happened 2 years previously in the Ground Rent Reform Act was that the government said that all new leases couldn't have ground rent. So from a certain date, I think it was the 30th of June 2022, there was no new leases with ground rent. Now what that meant was you had a two-tier system. You had existing leases with ground rents, sometimes upwards of £500, £800, £1,000. So ground rents are payment paid yearly to a landlord for no reason whatsoever. And then you had new leases with no ground rent. So, if you could potentially have a block of flats where half the flats weren't paying ground rent and half the flats were, depending upon the time which they bought it. And so we were hoping that with this new piece of legislation, the government would either abolish ground rents from existing properties, level the playing field, or freeze ground rents at a certain level, and it didn't happen. So what we find from that legislation is that although it's improved things, and it's improved things in the sense of it's made lease extensions, or it potentially has made lease extensions cheaper. We're not sure yet because it's very technical. It may have made lease extensions above 80 years more expensive. We don't know. We haven't seen the full detail of legislation, but it certainly made lease extensions below where there's 80 years or left cheaper. But what we've missed is an opportunity of that legislation to actually make a big change in relation to leaseholds. And I think that the new government that's just come in recently have said, you know what, ideally we don't like leasehold. We want to move across to common hold, and we're going to enact some legislation, we haven't seen the details of it yet, to try and force people across to common hold. And you tend to find in law, until people are forced to do something, they won't do it. So it's the old inspiration or desperation. No one's ever inspired. There's no inspired lawyers out there. They're all desperate when they have to make the change, right? Yeah. And I think that the legislation that's in now is useful. It gives tenants more rights in relation to management of their blocks. It gives them more powers in relation to undertaking a lease extension. Currently, when you buy a property, you had to wait 2 years before you're allowed to extend your lease. Under the new rules, it's instantaneous.
That's a great move.
There used to be this concept of marriage value. No one in the industry understands what it is. I've never spoke to anyone that's got a clue what marriage value is, apart from chartered surveyors. But basically, it meant that once a lease was below 80 years, it was more expensive to extend. That's been abolished. And therefore, that's why I said it make it cheaper to extend leases under 80 years. But the way the legislation's written, we're not sure about leases over 80 years. So there's some confusion there. It's given more rights generally to tenants, but it's fallen short of undertaking a full reform. I think to call it a reform act is pretty poor, because it's more an evolution, not a revolution. And we were looking for a revolution, because those that have done this for a long time know leasehold's not fit for purpose. We're stuck with it. They don't have it in Scotland. They don't have it in most European countries. They don't have these issues. We are unique in the world with this funny system called leasehold that no one seems to understand. You know, America, they have a condominium type of ownership, which is basically common hold. And that's what we need to move to here in relation to our flats and apartments.
It's going to be interesting to see how it evolves. And MTVH, I'm pleased to say, are sort of ahead of the game, because wherever we're the freeholder, we have scrap ground rents, we have scrap marriage value. So we've been doing that for some time now. And again, just as it is so important to get a lawyer that understands what they're doing, equally with surveyors too, because there's been so many times where we're reviewing RICS reports that come in and they've not used the correct calculations and they've charged marriage value. And it's another reason why, if you are going to a housing association, have a look at their panel recommendation. The panel surveyors are there for a reason. For us especially, if you go outside of that panel, especially if you're looking at a lease extension valuation, you could end up paying more if you go elsewhere. So it just highlights the importance of that as well. So other than obviously the leasehold reform, we've touched on building safety. Let's have a look at service charges, because that has been huge in the press, and it's something that I really would like to discuss. I think a lot of the press has been around shared ownership, but actually it's not just shared owners. It is leaseholders in general. I'm just really keen to get your view, because I know you've got some thoughts on it.
Yeah, I mean, I think service charge is one of these things that you go and you look at a really lovely block, and in that block there's a gym. I saw one recently with a cinema.
Oh wow!
You have all these facilities, and there's a reality to that when you live in a block with underground parking and gyms and cinemas and all that stuff. Someone's got to pay to maintain that. So there is this inherent need for service charge, and the more services you use or have access to, the more you're going to pay. Now, just to sort of step back a little bit, the first thing we tell all of our customers that buy shared ownership is that you are buying a share. Quite often 25% to 40%. It's quite common in relation to shared ownership. And so you're buying a share of this property, you will pay rent on the other share you don't own. Great, everyone understands that concept. You will also pay service charge in relation to the services in the building, but you will pay that at 100%. So although you own 25% of the property, you're also going to pay 100% of the service charges because you use the services. It's not fair for the housing association necessarily to pay those services because they're not using those services. They don't take the benefit of that. And therefore, I think with shared ownership, the reason it looks worse in relation to when you see stuff in the press is because people say, well, I paid $50,000 for my 25% share and my service charge is £3,000 a year. Well, yeah, your service charge may be £3,000 a year, but that's 100% of the service charges. And I think that sometimes, when you look at the negative, and I'm not here just to sit here and say, you know what, shared ownership's amazing. I love shared ownership and I've been around it since 1990. Right, so I love it. I was raised in a shared ownership house, but it's not all amazing and not everything is perfect. And one of the sort of downsides is that you can own a small percentage of the property, but still have to pay 100% of the service charge. Maintenance charges. I know that shared ownership leases have changed fairly recently, and there are a number of changes down the last 25 years of leases. And now there is some form of contribution in relation to new leases, or there can be from the housing association, but traditionally there was none, and the individual who owned that property was paying 100% of the service charge. And I think that is a negative that people need to understand from day one. There are many positives. You own the property, you get an uplift in its value if it rises in value, etc. You also lose if it goes down in value.
Yeah.
So we can win and lose. But that is an issue. Now, if you're looking at a block and it's got multiple lifts, gyms, underground car parks, it's going to be expensive for service charges. And the more of that stuff you have, the more expensive it is. And I think that when people look at blocks, they should look at reality. What do I need? Where do I need it? Do I need that gym, or am I already a member of a gym down the road that's costing me £20 a month? Do I need the parking space? What do I need? And if you buy what you need as opposed to what you necessarily want, you'll reduce the service charge. And if you don't have a lift in a block, service charge will be lower. Lifts are notoriously expensive. They break, they go wrong, they have service contracts, they get old, they need replaced. This part goes wrong, you get stuck in them, the fire brigade come and get you out. It's happened to me many a time, right? Ultimately, I think when you're looking at service charges, you need to look at what is the need? Do I need all that stuff? However, I qualify all of that and I say one thing. There are unscrupulous people out there. And part of the changes in the Leasehold and Freehold Reform Act recently was in relation to try and make it more transparent as to what management companies can charge and make it much easier for tenants to raise concerns and complaints about those. I believe there's an ombudsman being set up now where tenants can go to in relation to issues with service charges, because there are companies out there, and I'm not going to name them, that frankly are outrageous what they charge in relation to their fees, for their professional fees for maintaining the services, for dealing with the admin, for collecting the service charges, and ultimately that affects shared ownership owners as much as it affects anyone else. This issue is not a shared ownership specific issue. This is a wider market issue. This affects everyone. In fact, I saw a term the other day in relation to even freehold houses called leaseholds, where the press had called a development a leasehold, and what it was there was a big development of houses, and there was a management company charging to cut the grass, maintain the roads, and they were charging the residents about £10 a year for that because there wasn't much to do, but they were charging them about £120 for their professional fees. They were charging them £120 to charge them £10. It makes no sense. No. There is an issue with service charges. There is an issue with the costs of maintaining these buildings as they get older. The other thing to consider is that if you buy a brand new property, it's got brand new roofs, it's got brand new supports, foundations, everything's brand new. There's probably not that much to do to it. If you buy a property that's 20 years old, the roof's getting old, the lift needs repaired, those types of properties may have other issues. And therefore, the service charge may be higher in relation to those. So it's one of these things, you're not going to escape it, but I think with the changes to legislation, and also I think generally, it's better with housing associations than it is elsewhere, in the sense of the housing association's role is to put people in home ownership. They're not for profit. One of the my big bugbears about this industry is there's so many people in this industry making a profit out of where you live. And I just don't know if that's right. I know that people make a profit out of when you drink water, but I'm not sure that's right either, right? But I think, this is the problem with service charge, with leaseholds, with leaseholds, any form of service charge is people making a profit out of them. And whenever that occurs, that's expensive for those people paying it. So
we've covered off pretty much all of the different aspects of shared ownership and what it really means to own a shared ownership home. There are other products out there, and I'm sure there will be more to come as it evolves. But fundamentally, do you feel that shared ownership works? What are the alternatives?
So just, not to bore you, but put it this way. In 1990, I was 11. And my dad was leaving the RAF. We had no house. He wasn't commissioned, so we had very little money. And he signed up to a scheme we never heard of before called shared ownership with network housing. I'm not even sure if they still exist now. They've probably merged with someone else. And he received a phone call and he said, there's 1,000 people on a list to buy this property in Harrow, Northwest London. The first person that gets here will pay £100 and they'll get the property. You have to pay £100 reservations. My dad jumped over the sofa. I remember it well because Elton John was playing in the background, Candle in the Wind or something like that. And my dad jumped over the sofa and I said, "Where are you going, Dad?" He said, "I've got to go and get us a house." And he ran down there, he bought this house. We bought 40% in 1990 before, I don't know if any people remember, the historians out there remember the Conservative government later entered the ERM and interest rates went through the roof. And he bought his 40% share and we moved into our 3-bedroom house with a conservatory on the back via network housing. He paid his rent on the rest. I did my GCSEs there, I did my A-levels there, I started my degree there. I am here now because of living in the shared ownership property. Funnily enough, he bought his 60%, he bought out the rest of it, he staircased to 100%, and he paid less for his 60% than he paid for his 40% because the economy crashed. 92, 93, house prices dropped dramatically, and he was able to buy his 60% share, and that worked really well for him and us as a family because we ended up owning 100% of a property. We couldn't afford to have done that ever. He then sold that share ownership. We moved on. We've done well since. The whole family's done well. But share ownership is necessary. It's fundamentally necessary for the UK. If you go to Germany, Holland even, maybe even Switzerland, people rent for 20 years. There's rent controls. People are allowed to rent for 20 years. It doesn't exist in the UK. We don't have the rental system that the European, the continent has in relation to property. We need either that system to be here or we have a need for shared ownership. It's not all rosy. There are issues. People often are not happy about the services provided, but that exists in the general market. All those issues that shared ownership owners have generally exist out there as well for everyone in all ownership of any property. So in a country where owning your property is still a fundamental, is something that's pushed on us, where house prices have risen 400% since 1970 or 1980, and if you look at Switzerland, house prices have risen 173% in that time. So our house prices have risen 400%. There's 173. There is a need for the product. The product is fundamental. It's needed. We probably are going to see a situation now where a lot of government schemes have moved away from the property market. For the last 12 years, we had something called Help to Buy. Help to Buy was a government-funded scheme where you bought a new build property and you took your mortgage, you put 5% deposit down, and you got 20% or 40%, depending on where the property was, for 5 years at no interest. That scheme's gone. That scheme also, allegedly caused prices to rise quite dramatically in relation to new build property. I don't know the detail, but there's a lot of people out there with opinions on that. And those schemes have sort of gone. Your options now really are you rent, buy shared ownership, or you buy on the full market. And I think the reality is, particularly in London and the southeast, shared ownership is massively needed. We need more of it. And I think now, particularly where you've got housing associations saying, look, we accept responsibility for fixing stuff, that's brilliant. It works and it's needed.
Yeah. And I think the way that potentially shared ownership has been marketed, with some organisations is that it's sort of tailored towards lower income families, but it's not. It's not for low income families. And if you would be concerned if your boiler broke down, shared ownership just isn't right for you. It's for average income households. It's an alternative way of getting onto the property ladder without going onto the open market. Yeah. So it's absolutely an entryway of owning your own home. And your story is so common. And I was actually doing a project only a couple of weeks ago, and I was having a look at all of the transactions that we completed on over the last couple of years. And I was trying to drill down whether the leaseholders had made money on their investment or lost through down valuations. And I have to say, I was really pleased by the outcome of that project, and we will publish those results soon, just to give people a flavour. But ultimately, that there are some down valuations. Your family experienced it, and actually they benefited from it because they staircased at that time. But it's an entryway into owning your own home, and if you invest in your share and prices go up, you've then made enough equity to then go on and buy on the open market if that's what you want to do. But unless you buy freehold, you're still going to end up with some of the concerns that you might have with service charges, management issues, because unless you buy a house, you're going to need to buy a flat.
Yeah, no, that's right. And I think that's the thing, that there's an expression out there, it's called skin in the deal. And shared ownership gives you skin in the deal. House prices in the long term, they rise generally. Listen, past performance is not an indicator of future performance in anything. But generally, over the longer term, maybe Oscar Wilde or someone said, buy land while you can, because they don't make it anymore. I don't know if it was Oscar Wilde, it was someone like that. But the point is, generally on the long term, it's the right thing to do. If you're in to make a quick buck and buy anything quickly and sell it, it doesn't matter what you're doing, what you're buying, whether it's cars, stocks, shares, houses, you can lose. But in the longer term, most people in our experience have done really well out of it. And, like I say, if it does fall in value, you staircase. There's no better time to staircase than when prices are falling. You get it for less money. So that's the best time to staircase, And ultimately, I guess if you need to own a property, you've got two options, haven't you? Most people, lawyers don't make enough money to buy a house outright these days. Doctors don't, so you've got two options. You keep renting and paying a landlord who's making a profit, who's there to make money, or do you buy and get some skin in the deal and get some of your own equity in the property? That's your options. There isn't really a third option out there.
And renting's proving a bit more challenging now at the moment. I mean, I'm seeing more and more private landlords, removing their properties from the market. I think with some recent press updates as well. We won't go too deeply into that. But I did interview a financial journalist a few episodes ago, and she did predict that rents in London would be going up by 26% by the end of this year. It's slowly starting to happen. I usually, take predictions quite lightly, but I can see it coming.
Yeah, I think, ultimately supply and demand dictates any market unless there's controls from governments externally, and therefore that's ultimately the place. I think the current government has suggested rent controls. They suggested enhanced rights for tenants. That's welcome. I think anyone that's sensible in this sector would say that stuff's really welcome. Will it go far enough? What will the details say? I'm not sure. As it stands today, as we talk in relation to this, if you rent a property, you are paying someone's mortgage, you are paying someone an income, you are making someone else a profit. That's where it stands today.
Exactly. Lovely. Right. Well, I think we've come to the end of our time now. And as you know, I like to try and end the podcast with something a little bit more lighthearted. Now, I know that you can't necessarily tell me about anyone famous that you might have worked with, client confidentiality, but I know that a lot of lawyers that I work with, they've always got that quirky story, something that really stands out. So is there anything that you can share with us before we go?
Yeah, I mean, we've acted for a number of people down the years. It's impossible to ever say who, but there's one particular person about 21 years ago who is a world leader and unbelievably selected our firm, a small firm in Berkshire, to come and visit in relation to a matter that was very pressing for him. And we had to close the office. We had a lot of security in our building, and we gave advice to this world leader who actually amazingly didn't take our advice. Probably, without going into the detail, I can't tell you the detail, but let's just say he's a very wise person, and we wish we could publicise who that was, but they didn't take our advice and took other action. Now, that happens all the time. Lawyers are there ultimately to give you their opinion, or help you form an opinion, but it's your decision. And I think that applies to our clients generally. We're there to inform, advise, assist, but we're not telling you what to do. You make the decision. And it doesn't matter if you're a world leader or you're buying your first shared ownership house in Harrow, northwest London, like my dad. He still makes the decisions.
Amazing. I'm really intrigued to know who that is now. But thank you, Paul. You've been an amazing guest. And thanks to the listeners. And remember, if there are any topics that you would like us to cover, please do comment or drop us a message. You can find us on YouTube, Spotify, Apple Podcast, or all the other main podcast platforms. Thanks again for listening. This is So in the Know.